The podium.
Thank you so much for coming in. It's so great to see so many familiar faces. I'm Ann Phillips, and hopefully in the next hour or so, I can impart some valuable information or information that you find valuable in this practice. It's really, really warm in here. We had this door open because down south it's freezing. So it's a little bit cooler to the front. Otherwise, my assistant, Stephen, who's helping out with IT today, you'll see him running around all week helping others. He's going to run and see if there's something that can be done to help others in here. So usually we're freezing in these rooms, right? So I won't belabor it, and you might actually have to get out a few minutes early if it doesn't get to you. All right, so I'm Ann Phillips, and I just served almost a 4-year sentence on the Maricopa County bench. And the day after I retired, I had been in the county many years, I called Gary Kula and said, Gary, I really want to talk at APDA because I have a lot to share. And he said, can I get you for the next 10 years? And I said, well, sure. I mean, if I'm alive and I'm still walking and I'm still talking and I still remember this stuff, you have me for the next 10 years. So we're going to talk today about secrets that I learned on the bench, looking at things from a judge's point of view after having practiced for many, many years, things I observed lawyers do and not do, and things that I think might be helpful to you in the future. That's me at the legal defender's office where I was for a very long time. I graduated with my Juris Doctor from ASU in 1988. For 10 years, I didn't really want to work for anybody else, so I had my own practice right out of law school where I did criminal contracts and I did some family law. And then I wanted the public defender experience, so I went to the legal defender's office for the best part of 20 years. I took a couple years off here and there to raise young children and have a coffee shop, which is, another seminar. And then I was a commissioner for about 3.5 years. I was solely on the probation violation bench, and I appreciate seeing my friends from the bench, from my time on the bench. I also have an LLM. Several years ago, when my youngest went to college, I decided I needed to go back to school. So I also have an LLM for being a student in sports law, but that's completely irrelevant to anything we're going to talk about. But I spent a lot of money for it, so I went to and that's another day at the legal defender's office, me at the computer. So currently, I am retired from the county, but I'm adjunct faculty. I take undergraduate legal studies for Purdue University Global, so I consider my kids to be able to teach with a little extra money for my travel habits, and it's a lot of fun. So I'm pretty much devoting my time to teaching now. So, quick overview for today. You guys hear me in the back? Okay. So, quick overview for today. Oh, by the way, interrupt with questions. Okay. I am here to answer any questions. Just raise your hand, be polite about it. But let's make this as interactive as possible. Okay, I'd really like to do that because I'm here for you. Be polite and courteous to everybody in court. We'll start with that. That may seem obvious to most of you. It is not obvious to a lot of lawyers. But be nice to everybody. Be nice to the court staff. Be on time, even on calendars when you know it's going to take an hour and a half to get to your case. And I'll explain why in a moment. Be prepared when you come to court. Follow the ethical rules. We're going to spend some time on the ethical rules so that you can get. Does someone have something? Follow the ethical rules. Again, I know that seems obvious, but in order for you to get ethics credit for this session, we have to go over some of them. Okay? And know who you're appearing in front of. It's very important. Know who you're judicial officer is. So that's sort of our agenda for today. Also, this is all posted on the website. All my materials, including the PowerPoint, is uploaded to the APDA website. If you loved it so much and you want to watch it again later, you can do that. What happens at APDA stays at APDA. Do we have any first-time APDA attendees? Anybody who's been here the very first time? Okay. What happens at APDA stays at APDA. Okay, talk to anybody else in your offices. That means, to me, this is probably my 20th APDA attendance, but I've been on hiatus for 4 years, so I have a lot to talk about. Let's have a really frank conversation. Okay? There's nothing you can't ask me. I might later say, let's maybe talk about that privately, but because I don't want to get on the record for some of the stuff, but I'm happy to answer any questions to help you. I've learned things in my time on the bench that I wish I had known when I was practicing. And again, don't interrupt with questions. I will never lie to you. And all right, time to play lawyer, not a lawyer. To kind of keep everybody's attention and make sure it's interactive, I put together just a few little fun fact things about people who may be lawyers, people who may not be lawyers. So we'll start with that. Anybody know who this handsome gentleman is? You're close. It's not Russell Butler. It is. Any one of the ladies would know it's Gerard Butler. Is he a lawyer? Not a lawyer. He is. Fred says he's a lawyer. Anybody think he's not a lawyer? Not a Fred says. Can I just embarrass Fred for just 1 second? So, if you don't know Frederica Strunk, everybody, she's been with the Public Defender's Office for a very long time. She is the Yoda of mental health in Maricopa County. And everybody comes to her with their questions. She was one of the few lawyers that I actually recused myself on when she came to my court, and it used to really piss her off. But really, it was a compliment. It was a compliment because I knew if you were there, I could believe everything you said. And we're going to talk about credibility at length. Okay, so it was a compliment. Okay, so George Butler, Fred says lawyer. He's a lawyer. Who knew, right? He went to Glasgow School of Law. He's done lots and lots of movies, probably most famous for 3 Sunset. So we'll do a few of those over the course of the next hour. Okay, be polite and courteous. Hello. Everybody's mother taught us this when we were 2 years old, right? You cannot believe the shit that JO put up with lawyers who are not polite and courteous. And, you know, I don't see anybody here that I would look at to say that, but it's true. I had a lawyer, I'll say his name later for a cocktail maybe, but one of the lawyers who would come to court and he'd be get dressed. He'd be, you guys probably know what I'm talking about. He'd be getting dressed, he'd be putting on his tie, buttoning up his shirt. And I had this, you know, like the first time I just watched him. And then the second time I said, Mr. So-and-so, do you think you could come dressed to court? And he just acted surprised. So being polite and courteous, just being aware of where you are. I know public defenders are in court, you know, all day, every day. It kind of becomes like a second home, right? I have spent most of my life in a courtroom. I'm very comfortable in a courtroom. And depending on the JO, maybe it's a little casual atmosphere. I tended to have sort of a casual atmosphere in my court. But that does not mean you should not be polite and courteous at all times to everybody, to the staff, to anybody else. In my courtroom, I had a probation officer. You can't believe the people that were rude to the probation officer. Like, you know, the probation officer is there to help, right? And people were rude. And, you know, there are just lawyers that just don't get this. My mother always taught me, you get more bees with honey. It works in the courtroom. It did work in my courtroom, I guess. Because the court staff is always going to let the JO know. Yeah, they're rude to the courtroom assistant. They're going to tell their judicial officer. In fact, I've instructed my courtroom assistants. If someone is rude to you, you come to me, and I will fix it. Or you know, tell them, hey, you know, I just want you to do this. And if that didn't work, then I would call them out. And I did have to do that a couple of times. You know, nobody likes being called out on the record. I remember many times being called out on the record by a judge, usually for no good reason, right? And I resented it. And it's embarrassing, sometimes it throws you off your game. And I didn't want to ever do that to anybody. But sometimes these lawyers don't get the subtlety. There was a lawyer who had a chronic issue in my courtroom, and he made some snarky remarks to my courtroom assistant, who was authorized to say, you know, the judge doesn't want you to do that, please don't do that. And he said, well, we'll see. Needless to say, the next time he was in my court, I called him out on the record. Nobody wants that. It really, really hurts your credibility, and you know, that's all you have in this profession, is your credibility and your reputation. Think of this presentation as sort of like traffic school, right? We all know how to drive, right? But once in a while, it's good to have that refresher. So that's kind of my approach that I'm taking here today. So, you know, everybody knows who the jerks are. The judges all talk about the lawyers. You know, when I was practicing, right? When I was practicing, the panel said, hey Steve, can you see if we can get this room cooler? Go find Gary or somebody to see if they can do something, please. I'm okay. I'll be okay without you for a few minutes. Because it's really, really fun here. So when I was a lawyer and I had friends on the bench, they would say, oh, we're too busy. We can't talk about the lawyers. We don't care. We don't know who they are. That is bullshit. That's all we do. That's all we do is talk about lawyers. And usually it's bad. But, you know, I said good things too. You know, after a particularly rough morning, I would honestly say, that thing with Tyler, it's such a breath of fresh air. She's prepared, she's nice, she always has a smile on her face. And when you have 90 cases on a probation calendar, it really, really goes a long way. And, you know, because of that, she had a lot of credibility with me because she was prepared, and she was really nice. And we were children, but I would maybe come back to the my partners on the bench were Therese Gantz and Rodney Mitchell. Many of you probably know Rodney, a long-time public defender, great guy. Therese Gantz, newer to the bench, but he was in the world. I come to the back and go, oh my God, everybody's an idiot except, you know, Dana or John or somebody. And I was very lucky. I had a lot of really good lawyers in my courtroom, but there were a few bad ones. So we talk about it. We talk about it once in a while. You know, I know Gary Kula for many years. There was someone from the public defender's office. I go to Gary and say, slap this person is not behaving in the courtroom, this person is not doing what they're supposed to be doing. Fortunately, I didn't have to do that very often. But judges, and honestly, if I didn't know Gary and I already have a relationship with him, I don't know if I would have done it or not. But just be aware, people know who you are, good and bad. The bottom line is, if you have a bad reputation, it could impact your client negatively, and we don't ever want to do that. Many years ago, before I went to law school, I was a bailiff in Superior Court for John Stitch. I don't think there's anybody here old enough to remember Judge Stitch. Do you remember Judge Stitch? Sure. Okay, so I was his bailiff the summer before I went to law school in 1985, when I started law school. And he used to say to me, when you become a lawyer, don't be a jerk, first of all. But he would say, when you become a judge, don't ever hold it against the client if the lawyer's a jerk. And he obviously told me this very, 40 years ago, and it always stuck with me. Just because the lawyer is a jerk, don't hold that against the client. But the reality is, if your lawyer is a jerk, and the judge questions your reputation, your word, your lack of preparedness, that is going to hurt the client in the long run. And not every judge is ethical as me. Not every judge comes from the defense bar. A lot of judges didn't even come from litigation, so they're not as cognizant of what goes on in the courtroom. We'll get to that at the end when we talk about notice judicial action. So JOs really are human, and they do really respond to niceness, even the nastiest ones. And I've learned this morning who everybody hates. I won't say publicly, but it doesn't surprise me. It's also a really good cover for ignorance. If you're not really sure, or your case is really terrible or really weak, or your client's just a total being really nice actually goes a very, very long way with the court. If you're not sure what your argument is, or you don't have an argument, sometimes just being nice, the judge will think, good try, good college try. So politeness and niceness really, really does go a long way. And the decorum, is very important because it promotes respect and order to the court. Respect and order in the courtroom. And one of the things that always bothered me when I was practicing was the lack of decorum in so many courts. I did a lot of work in Rule 11 court, and I couldn't believe the lack of decorum of some of these people on the bench. It's like, why does the judge not say something to this person? Or, a defense can be really rude, or, rude to their, and this goes to, Fred, what you were asking me, the lawyer clearly was not engaged with their client, or were, standing far from their client, or not acknowledging their client. And it looks really bad, and I never understood why a JO would not call the lawyer out, or just in a nice way. Mr. So-and-so, can you stand next to your client? Mr. So-and-so, your client has a question. If you want to take a minute and go talk to your client, because we all know, nobody in this room, but there are lawyers that don't ever talk to their clients, or they don't talk to them before they go to court. It's terrible. And so I would allow the lawyer the time to do that. Say, we have a few minutes, why don't you go talk to your client? Always say yes when the judge does that. All right, dressing appropriately. I don't think I ever had lawyers dress inappropriately. There was just the one, like I said, who would like to get dressed when he was in the court. And I fixed that. Always address the court respectfully, even when the court's not respectful to you. Anybody go to ASU Law School and remember Hugo Zettler? Hugo? Yeah. Okay, so Hugo Zettler was a longtime practicing attorney. He was an adjunct faculty at the law school, and he taught prosecutor clinic. And one of the things he taught us when you are in the court, presentation is everything. So if you object and the judge denies your objection or overrules your objection, you should go, "Thank you, Your Honor." And always be pleasant because it confuses the jury. If you're overruled and you're happy about it, it confuses the jury. So I never forgot that. So I never forgot that. But people have forgotten respect, but it's really the judicial officer's job to direct the courtroom. And I had a very chaotic courtroom. For those not familiar with probation violation court, on any given day, we have 90 or 100 cases on the calendar that we had to get done in the morning. And there was a large chain, the gallery was usually pretty full, lawyers in and out. It was a three-ring circus every day, 5 days a week. And that's the first thing I had to learn. And we'll talk about that tomorrow if you're signing up for, so you want to be on the bench and you're thinking about applying for the bench, and we'll talk about that. You're a referee, and depending on which court you're in, and I had to referee, I had to watch what was going on in the courtroom, I had to watch the chain, I had to watch the lawyers. There's a lot going on at once, and so if you are responsible, the judge, again, it goes a very long way, because it can be a very uncivilized place, as we all know, right? It can be very, very chaotic and very uncivilized. So you be the civilized one, all right? Always think about our mission and what, and I still say I will always be a public defender. I'm a public defender at heart, and why I wasn't in love with being on the bench. It is a secret duty being a public defender. It is the best job a person can have in our country, in my opinion. I have always felt that way, and I hope that you feel the same way. But even if you don't feel the same way, it's our job to be, to raise the bar, to be the creme de la creme of the bar's reputation, because people say, I'm a public pretender, be the one to raise the bar. Be the one that has clients and says, you're the public defender. Clients tell me that, no, it's a nice compliment. All right, lawyer, not a lawyer. Who is this? It is a lawyer, not a lawyer. It's a little tricky. Yeah. What do you think? You're not a lawyer? Okay, let's see. Lawyer's not a lawyer. He was a lawyer, but he dropped out of law school. But he was able to pass the bar anyway, and apparently back in the day, you could do that. And so when I was preparing this, I researched, and because I wondered, are there any states where you just take the bar without a law degree? And actually there are. I don't remember what they are, but there are actually some states where you can. California? Yeah. California?
Washington State and Virginia.
Okay, thank you. All right, of course, he's the 32nd president of the United States. So he was a lawyer, but he didn't have a law degree. All right, point number 2, please be on time. Please be on time. I know judges are late to the bench. We all know who they are. Punctuality was important in my courtroom. If you're gonna be late, just email the courtroom assistant. Go ahead.
Why are those judges late to the bench? What are they doing?
Let me tell you. So, in the late 1990s, I stopped apologizing for the O.J. Simpson verdict. Okay. So to juries, when I was in front of juries and they were still thinking about the O.J. Simpson case. So I stopped apologizing for the O.J. Simpson verdict. I've stopped apologizing for other judges because I don't know. It was important to me because as a longtime practicing lawyer, I had hours and hours sitting in a courtroom waiting for a judge to show up. Those hours I will never get back in my life. We all know who we're talking about, right? And there's a lot of them. It was important to me to be on time. And I think there's just a certain arrogance that goes with the position, and it's like, they have to wait for me, and I find that disappointing. And it's why I was only on the bench for a few years instead of 20, because, well, partially my age, but also because I just didn't understand. So I don't apologize for what other people do. There's no good reason. There's no good reason. Just arrogance. But I'm not going to apologize for them anymore. Okay. So learn who the staff is. The best thing you can do is be friends with the courtroom assistant, especially if it's a courtroom you're in a lot. Just send them an email. That's really all we ever ask for. Hey, I'm in Judge so-and-so's court. I'm running late. I'll be there as soon as I can. It's great. And the reason is, the judges who don't have a defense background, they don't understand your schedule. They don't know you have to be in 3 places on 3 different floors and 3 different buildings at 8:30. They don't know that unless they've had the defender experience. So, that's why it's important to know your JDOT. We'll get to that on number 5. That's why communication is so important, okay? They don't get that you have to be somewhere else. And they get mad, and a lot of times they'll screw you. You know, they'll just leave the bench and then you're screwed and you show up and they're like, too bad, I continued it. You know, there are judges that are just nasty for no reason. And I think a lot of it is they just don't have a litigation background, or maybe they came from a big firm where they were paid too much. I don't know, like I said, I don't apologize for them anymore, I don't have any friends there, but, that's my guess. But, you know, understand that communication is the most important thing. Just an email goes a long way, in not pissing off the judge. And of course, the other thing is that the court calendar, although it may not appear that the judges are busy, the good judges and commissioners are really busy. And like my calendar, 90 cases, you know, I just couldn't come, you know, or we would have witness hearings in the afternoon, so we had to get everything done in the morning, or judges and commissioners have trials in the afternoon, they have to get everything in the morning. And like I said, it may not appear to be urgent on the outside, but it really is. So it really is important to be on. They know who's always late. We knew who's always late. There were always the same people that were late in my courtroom. And then the judges will send out an email to all the other judges and say, this is my daily hunt, my daily APD for lawyer XYZ. And we all would joke about it because we all knew who was late, and everybody was always looking for the same lawyer. So don't let that be you, all right? It really hurts your reputation, and it really pisses off the judge, and it does not make you look important. You know, going in and saying, I'm in trial and I have 42 other things in this county and that county, you know, okay, but I needed you here to do this. And for me, what I learned very quickly is if I came to the bench promptly at 8:30, which I did, the lawyers who knew that came to me first, and they could get their cases taken care of and done. So everybody knew, oh, Phillips is on the bench on time, I'm gonna go there first, and get it done quick, and be out of there. Another reason to be all right, again, if the court schedule is much tighter than it may appear, and some courts are tighter than others, and it screws so many people if you're late. It screws the courtroom assistant, it screws the clerk, it screws the judge, it screws the prosecutor. I know we don't care about screwing the prosecutor, but it screws a whole staff full of people. If my JA is in the back waiting for me to sign warrants or release orders, I can't do that if I'm sitting waiting for you to call your, not guilty arraignment in probation court. So just be mindful. I'll be very honest. I never thought about any of this shit when I was practicing. I was the great, defense warrior, and fuck them. They have to be there, and my client's rights and blah blah. But the truth is, they don't give a shit about it. Most of them. So it really does screw other people if you are late. Again, we knew who showed up on time and who didn't. The chronic tardiness really hurts your credibility, and it's also just rude. Your mothership talking about. All right, who's this? Jerry Springer. Now, for you youngins, who wants to explain? One of the older folks, who wants to explain who Jerry Springer is?
First of all, Jerry Springer raised millennials.
Exactly. Okay, I didn't know that. There is a doctor right now. Okay.
He had a show about throwing chairs.
Yes, he did. He was a talk show host, if you could call it that, very salacious, and really one of the first to have the wild and crazy, chaotic talk show with really crazy, stupid topics. All right, so was he a lawyer?
Yes.
Not a lawyer.
Yes.
He was a lawyer, and he had been married in Cincinnati, and he had his talk show for many, many years. He went to Northwestern. Yeah. Okay, please be prepared when you come to court. Again, this should be obvious, but I had lawyers that would come in, get up to the podium. Good morning, Mr. So-and-so. How are we proceeding today? Judge, what am I here for? I'm not kidding. So don't let that be you. And I know it wouldn't be anybody in this group, but don't let that be you. Know what the hell you're going in to do. Even if you're covering for someone, make sure you know what you're doing, preferably that you've spoken to your client before court. Sometimes that's not possible. I know sometimes if you're OPDS, maybe you get appointed at 4 o'clock the day before and you don't have time. But you know, another reason to get to court promptly, get in there and talk to your client before you get up to the podium with your client. I know this stuff is obvious. I know people are nodding. There are lawyers that don't do this. So if you can't talk to them before, make sure you do it as soon as you get there. There is nothing more embarrassing. It embarrassed me to see a defense attorney bring a client to the podium. They clearly had not spoke to the client to advise them, here's what's going to happen today. Here's what we're going to do. I'll talk to you afterwards. And the client would be standing there going, what the fuck is happening? and the lawyer's like, you know, it's like, that's when I would say, you know, your client seems to have questions. Why don't you take a moment? And I know you're rushed and busy, but, you know, the whole purpose is to represent your client. So, you know, go in the back, talk to your client for a minute, what we call it. Because it is all about the clients, right? Did we forget that? We forgot that, I think. You know, it is all about the clients. So again, unless you're appointed the night before, which a judge may not be aware of that. A judge might not be aware of that. OPS sometimes will email you in the middle of the night and say, I need you to be at a probation evaluation the next morning. But make sure and talk to clients at the time whenever possible. This is a big one. So I did a lot of oral motions to modify release, and the state, of course, would object and want to respond. So it's not unreasonable for the state to ask to respond to a motion. I had lawyers who love to make oral motions and say, can we just file a written response? And of course I have to say, yes, that is not unreasonable. So if you are able to file a motion in advance, please do so. So that the state doesn't want, I mean, we know they're gonna, you know, we know they're gonna object, we know they're gonna oppose it, but they do have the right to file a written response. So, because if you don't, the court's likely to grant out the request anyway for the state and to follow written motion. So ahead of time is great if you can do it. If you can't do it, a lot of lawyers wait till the night before, the morning of to file a written motion. Make sure the judicial officer gets a copy of it. All right, don't just assume the judicial officer gets a copy of it. My procedure, I just eliminated the middleman. I had a lot of staffing issues for a variety of reasons. We'll talk about that tomorrow. So you want to be a judge. And so I would tell lawyers, if you file a motion, just email it to me directly. CC the state, of course, and just email it to me directly. Go ahead.
When you do e-filing, this is more just a philosophical question of mine. When you do e-filing, what happens when the L's over at clerk of court get it? And what's that like several day buffer between e-filing and like anybody knowing that you filed something?
That is an excellent question. One that I asked myself almost every day. And once I figured that out, once I was on the bench, I told the lawyers in my court, here's my email address, send it to me directly. I don't know, yes?
Do you want to just CC it, or can you BCC the state?
Great question, actually, thank you, Stephen. No, CC the state, of course. And you want to, just like you're mailing it, right? You send the state a copy. I let the people in my courtroom know all the time. Here's my email address. I don't know why more judges don't do that, because there is what's called an electronic queue that goes to the judges. And this is one of the things that you have to do when you're off the bench for the day, is go into your electronic queue and sign shit and look at motions and all that. And listen, I don't know what the clerk of the court does, because it would be days sometimes before I would see something. And once I realized that was happening, that's when I told people, just send it to me directly. I had lawyers, if they had filed a motion that morning and I was on the bench, I said, just, you know, if you have it on your phone, just email it to me right now. I'll look at it right now. Or paper always works. Paper still is an acceptable form, but always have copy. So I don't know the answer, but it's screwed up. It's totally screwed up. So don't rely on e-filing to get to the judge in a timely fashion. I don't know why.
It's expected of JA, that you'd send, or JO, who you'd send it to. Unless I'm in trial, I've never had a judge with his email address, so it's usually the JA you send it to.
Yes.
And they usually get it out to the court immediately.
Agreed. And that was my practice also when I was practicing. When I got on the bench, I had so many JAs in 3 years. I think I had 5 JAs in 3 years. It was a revolving door. Again, we'll talk more about that tomorrow in my where you want to be on the bench presentation. And so that is the practice of most judges. But I realized very quickly that was not going to work in my court. At a very fast court, very high caseload, and half the time my judges, my JAs were out sick, were out with kids, all understandable stuff, but it doesn't get the work of it work done. And so it's like, I don't care what the other judges do. You may be getting an idea why I was not so popular with my colleagues now. I would just tell the lawyer, just send it to me directly. That way I'll see it, and I'll see it in a timely fashion. I don't know why more judges don't do that. There's nothing wrong with it, as long as you're copying the state. The state liked it too. Again, I don't apologize for what other JAs do, but you're right, most judges want you to go through the JA. And if you have a really reliable JA, it works, but I do not have that.
I have a related question related to like filing stuff in advance, especially like a high volume court, like probation violation court. So like traditionally in like, in front of judges, or with the sentencing, I filed a sentencing memorandum, but filing like a disposition memorandum in a high volume court, what's the balance of like how much information I'm putting in writing, how much time do the judges have to prep or their calendar, what's that balance?
Great question, Becky. I made it a point to read everything that came in front of me. And it's not, I'm not a martyr. I didn't spend 12 hours a day. I didn't go home at midnight. I worked a solid, came in at 7, prepared for the day's calendar, read everything, especially if the lawyer went to a trouble to write a decent disposition memo, I read it. I took the judge seriously. And again, I'm not saying I'm such a martyr or anything, it's just like that should be expected, right? The judge should read everything that you file. So, again, we talk about know your judicial officer, know who your audience is. Some will read everything. I hope my people knew that I read everything. I read every file. And as the months went on, I got a little quicker at it. But it depends on the judge. If you've been filing it in advance, the better chance that the judge will read it. Bring extra copies to court. Paper still works. So, you can even ask the JA or the CA, does the judge care if I email it directly? I don't know of any other judges that do that. I did that because I thought that was just the most expedient way. Look at me, not wanting to be a bureaucrat, right? Yes, dear.
So when you carbon copy the state, does it have to be a carbon copy or can it be a blind carbon copy? And would you be penalized if it was a blind carbon copy?
It should not be a blind CC.
Okay.
Everything should be transparent, obviously, when you're submitting to the other side. And so, and by the way, this rule that nobody seems to know, submit an order. Okay, not only is it the rule, but it's also, it's just so warm in here, I'm just trying to get through this and get them in here. Not only is it the rule, but it makes it really easy for the judge to sign off on it. That's a trick I learned when I was practicing, and I think I picked that up at a seminar. Yeah, send an order, and the judge goes, oh look, they have an order. Boop. So, but it's also a rule, so make sure you send a form of order, even if it's a motion for release, especially if it's a motion for release, and you want the judge to sign it, that gets sent to the sheriff's office to release your guy, if the judge grants that. And even if it's a motion to continue, send a form of order, please, as Rule 1.9F tells us what to do. So I highlighted it and put it in red because nobody does it. Nobody does it. Not nobody. So, okay, so I grew up in a day before we had email, before we had paperless and all that. I always brought 10 copies to court of everything for everybody if they didn't get a copy. And so, the paper still works. You can still bring a paper copy to court so that you have it to give to the judge. You can, of course, email it to the judge if the judge lets you. The judge can look at it while they're on the bench. But I'll tell you what, I loved it if someone just said, there's copy of motion. And I didn't have to diddle with waiting for it to download because I had shitty internet in the basement of the Central Court building and really slow. And I could just look that, ooh, okay, granted. It was a state thing. Okay, thank you. And so even though I know it's old school, if you have something really important that you want the judge to grant, it's a good idea. And again, not all judges will do this, not all judges will do it on the spot. I never wanted to create work for myself afterwards. You know, there was so much work. If you didn't get it done today, you know, there's already 100 things for tomorrow. You never wanted to roll anything into tomorrow. So not all judges will do it. I like to do it that way. I like handling stuff immediately. And I was fortunate enough, my calendar allowed me to do that, right? Probation violations, you can pretty much get through those pretty quick. But I would just get it done and just spend a few seconds. I'm going to take 2 minutes and read this. Try and have your documents on a laptop or a tablet or paper, because this looks like shit. And I'm talking to Gen Z right now, and some millennials too. This looks like shit. And so I don't know, I'm the judge, I don't know what the fuck you're looking at. Are you looking at not something that applies to your client? Are you looking at your fucking Instagram page? What are you looking at? You know, and it looks
TikTok.
like, you know what, it looks like shit, and I won't say the lawyers that did this. They're looking at the petition to revoke or the disposition documents or whatever in there. It's like they clearly have not read it before court. That is terrible to do to your client. I don't care if you have to represent your client for 5 minutes and you have to go off and be somewhere else. My God, imagine how you would feel if you were that client. Oh, my lawyer didn't even fucking read it, he's got it on his phone. So, of course, it's acceptable practice. It really looks like shit. All right, so if your office doesn't give you a tablet or a laptop, it's nicer than this. Or print it out. Okay, who's this nice lady? It is, it's Rebel Wilson. What do you think, lawyer? Yeah. Lawyer. I hear some yeses. I hear some no's from the senior gallery. What do you think? Yes. She is a lawyer, believe it or not. She's also lost a lot of weight since this picture. She's an actress, she's a very funny actress. She's in the Pitch Perfect trilogy and many other movies. She went to the University of New South Wales in the UK, and she decided she graduated law school and would rather be an actress. Okay, so here's the ethics portion of our meeting. Please follow the PRs. Hopefully I don't see any super young faces in here. I know there's a couple of first-time attendees. This is so important. You can't believe lawyers that don't do this. This really hurts your reputation for honesty and integrity. You don't follow the rules, or don't seem to know the rules, or you know the rules and you ignore the rules. For the younger people in here, your credibility and your reputation is all you have. That's all you have, especially as a criminal defense attorney. So if the judge knows you're ethical, all the other judges are going to know you're ethical. Shows the court that you can be trusted. So when you get that difficult motion that you really, really want the judge to grant, and the state's jumping up and down and stomping their feet and opposing it, the court knows they can rely on your motion and your information. So There's the rules, if you're not sure how to look them up. There's the QR code, there's the link, and, you know, it doesn't hurt to review them, you know, traffic school, we all know how to drive, but it doesn't hurt to have a refresher. Those are the rules. We're gonna go over a few of them. This should be very obvious, but it's not. It's not. And I would say it's not, especially to the prosecutor, but we're not talking about that right now. Okay, so the very first rule is about competence. And competence means different things now. When I graduated law school, competent meant know what you're talking about, know what area of the law you're practicing in, be on top of CLE. In fact, I practiced law so long, I started practicing before CLE was mandatory. So you had to be, yes, so you had to be on top of the law and current on the case law so that you could properly represent your client. But now, the APDA has said competence also includes the benefits and risks associated with relevant technology. So if you're a technophobe or you're not sure how the practice fits in with current technology, you need to be competent in that for many reasons. Go ahead.
In your work, have you started to see AI generated things or things that you thought were AI generated?
Not that I could tell. So it's out there, AI generated evidence. And I'm guessing the other side's using it. I'm just saying, nobody in particular, I see nodding heads, we don't need to go into it, but be very, very careful. So if you don't know what AI is, how are you gonna know whether or not the evidence is AI generated, okay? So it's your duty, and there's some technology sessions here this week. I would encourage you to take them. How to get a client out of custody and you're emailing them, those emails should be encrypted. If you don't know how to encrypt an email in Outlook, learn how to do it. If you don't know what metadata is, again, educate yourself on what metadata is. It's the underlying data in a Word document. It can contain confidential information. You want to make sure you scrub that before you send that to the state. And you know, protecting your client's confidentiality online. These are all issues now under competence. Competence is at a higher level now than it was when I started practicing. You have to know technology. You have to. Diligence, acting with reasonable diligence, promptness, and representing the client. Very broad. What does it mean? Well, it means visiting your clients in custody, taking and responding to their phone calls, finding motions on time, doing necessary research, and showing up to court, preferably on time. I really like this comment, so I included it. This is the comment to the APA rule on diligence. A lawyer should pursue a matter on behalf of a client despite opposition, obstruction, or personal inconvenience, and take whatever measures required to indicate the client's cause or endeavor. You know what I thought about, John, when I was preparing this presentation, the day you ran out from Mesa out to the jail to give your client some discovery that had a deadline, and I thought, wow, like I never see a lawyer. I'm sure many of you do that, but I don't want to say that's the exception and not the rule. I know there's people that do it, but it's actually required. And I know it was personally inconvenient for you to do it that day, but yeah, it's actually, the rule said that is part of diligence, is to get it done. The client comes first. Procrastination. The APA has their own special comment about procrastination. A client can really be adversely affected by more procrastination. And lawyers are incredible procrastinators, terrible procrastinators. And we've all done it, right? Wait till the last minute to file a motion, wait till the last minute, I go see that client. You know, it causes your client needless anxiety, and it undermines the confidence in the lawyer's trustworthiness. And if you're representing people with mental health issues and they already have anxiety, this is really gonna fuck them up if they don't see you. You know, And so, as much as we all, I'll tell you, the thing I miss least about practicing is the jail visits. I don't miss that at all. But it's absolutely necessary. And if you have a problem with jail visits, I'll just say it. You should not be a criminal defense attorney. You should not be a public defender. Because that is part of the job, because that's what the clients are. So think about that the next time you put off that jail visit. Okay, time for a little fun. Who's this beautiful woman? Gemma Chan. Lawyer, not a lawyer? Lawyer. You sure? Yes. Lawyer. Okay. She is. She's a lawyer. And if you're not familiar with her, she was in Crazy Rich Asians, among some other movies. This was her most famous. She went to Oxford. So, see, there's hope for those of you who are maybe budding actors and actresses. You can do that with a law degree, but there are people that successfully do it. Steve, were you able to talk to anybody about the air conditioning?
Yeah, they said they'd send someone over from front desk.
Yeah? And how's that going? I apologize. I'll keep moving. Okay. All right, confidentiality. How many of you, I know nobody in this room does it, how many of you hear lawyers talking in the hallway or in the elevator about their clients' cases? Everybody, right? I had a prosecutor once, and I'm not convinced they are talking VRs. I had a prosecutor once in the hallway, that long hallway, if you practice Maricopa County, that long hallway where they used to have the dead judges, and now they just have the living judges.
The Shining.
Oh, right, it's true. The long hallway between the east and the central court building. I had a prosecutor stand at one end of that hallway, see me walking down the hallway, and say, I need to talk to you about the Joe Smith case. And I walked up to him and I said, can you not say my client's name shouting in the courtroom or in the courthouse? And he was like, so, confidentiality really is confidentiality. I assume that most everybody's office has the rule that the client of one is the client of everybody. You can talk to anybody in your office about cases. Okay, because there are some, I understand, large law firms that don't allow you to do that. You can only talk about the case with your team. But, so confidential means you can still talk to everybody in the office about it, but everybody in the office is also bound by it, regardless of whose client it is. One client for the whole office. So this is anything about the representation, anything. Even if you have a profile case and your client has talked to the media. Is Megan in here? Did I see Tim come in? Okay. I inherited a case from Tim that was a very high profile case, and I think I was the third lawyer on the case, maybe the fourth. I think she had initially hired private counsel, so she had worked through all the agencies until it came to the legal defendant's office. And she had done press conferences and talked on Nancy Grace and CNN, and she'd done all these interviews. She admitted everything, and I got the case. But I couldn't talk about the case, even though the entire world knew about this case and knew who she was. I could not talk about the case because it was my case, and the information was confidential between her and I. Now, unless the client gives consent, all right? And you might have that. You might have a client that, would love for you to talk to the press, and they give you their consent to do it, get it in writing. By the way, sidebar, did anybody see that interview with that guy accused of killing the minister in New River? What the awful. You know I'm talking about? The minister in New River was killed, and he just did an interview with Channel 10, and actually it really helped his mental health argument. He's clearly delusional, but does he not have an attorney listening to the attorney? How do these guys get to give, these one-on-one conversations with the press? I don't get it. Anyway, okay. So don't talk about the case, okay? You can, or actually you shall, 1.6b says you shall. That means you must reveal the information to the extent that you reasonably believe necessary to prevent the client from committing another crime that could result in death or substantial bodily harm. Without giving details, has anybody had this situation? I never had this situation. have you?
So that's brand new lawyer.
Okay. Can I ask, like, what did you do?
I actually had Jim Leonard come and talk to the client with me to assess whether or not it's a credible ME. And we determined that it was not credible.
Okay, good. Thank you for making my point. I was going to say, no matter how experienced you are, this can be a very, very serious situation. Consult with another lawyer in your office, a supervisor. If your office has an ethics committee, take it to the ethics committee and determine what should you do. Don't go it alone on this, because this can be bad, right? Now, there's other times when you may reveal confidential information, and that's other crimes that don't involve serious injury or death. Now, this is where the rule, I think, contradicts itself, because it says the lawyer may reveal the information to prevent the client from committing a crime or fraud. So I guess you have to decide what, bodily injury versus financial interest, which can be as devastating, in my opinion, especially if they're using your services to perpetuate that fraud. And if they've used your services to hurt someone financially, you are able to reveal. Now, the rule never says who you can reveal it to. So, do you go to the police? Do you go to the victim? You don't want to go to the state. So where do you go? And the rule really doesn't tell you. So get help on these. If you are having a problem and you need to get some advice from the ethics panel at the bar, the bar does have an ethics hotline. If you're not aware of, we'll give that information in just 1 minute. Call the ethics hotline. It's confidential. It's free. Well, it's our newspaper. And you can get some advice. You can also reveal any information that protects you as a client. If the client files a bar complaint or malpractice lawsuit, you can reveal, to the extent necessary, to defend yourself, any information about the case. Obviously, if the court orders you to do it, you have to reveal it. And again, this prevent reasonably certain death or substantial bodily harm, they have it under shall and they have it under may. So I think there's a conflict in the rule there. If you are, convinced your client really is going to do something bad, talk to somebody and figure out what to do. And then your two main reasonable efforts to prevent the inadvertent or unauthorized disclosure or unauthorized access to. And that's tricky because they have that buried way down there on E, but this goes to the knowledge of technology, right? You don't want your client's information to be hacked. You don't want your client's information to be accessed somehow on the internet. I used to, if I had an out-of-custody client, I would actually use snail mail to email the agreements, or to mail the agreements. I would not use email. Or I'd have the client come in and I would hand them the agreement if it was a sensitive case. I never used the internet, even though, if you work for the counties, hopefully the firewall is nice and strong. But, Maricopa County at least has, breaches all the time, where there's phishing attacks. So you have to make a reasonable effort. What's a reasonable effort? If you have a child molest case and your guy's out of custody and you got a plea agreement, I would either use snail mail or bring him into the office to go over it. Do not email it, even with the client's permission.
Can I add something?
Please.
I do email plea agreements.
Real loud, please.
I do email plea agreements. In fact, the client accused me of one time not giving the plea agreement in a timely manner, and I presented to the board that email. And there was no issue with that.
And you might even take your client's permission to do that. And if your client says, just email it to me, I would get that in writing. And advise, again, I would advise my client, it's not really the safest thing to do. Best practice, bring the client in and hand it to them. Or if it's a nasty subject police report, same thing. This was my practice. If your client is okay with it, just get it in writing. That's all. Now, I'm not saying it's per se unethical. I just think it can be construed under this rule, under reasonable efforts. Just make reasonable efforts. Okay? Same with the unauthorized access. People getting a hold of stuff on the internet.
Regardless if the email is encrypted or not, is it best to use snail mail no matter what?
I think that's a personal practice question. That's a great question, Stephen, thank you. I still use snail mail when it's something extremely sensitive, or better yet, just have the client come in so you can go over it with them. That, I think, is the best practice. And again, that's just me. I'm just here to give you some ethics credit and make some suggestions for you to think about. So here's the State Bar Ethics Hotline information. The nice thing about this, of course, it's non-binding, but if there does come a bar complaint or malpractice complaint, you can use it as a mitigating factor in your disciplinary proceedings. And I follow the ethics advice from the Ethics Hotline, so use it. But it's better if your office has an ethics committee. Our office, the legal defense office, did not have an ethics committee until we were in a session like this at some point, and we all decided, oh, it's really a good idea. So we formulated a committee. There were 4 or 5 of us on the committee. All of us had been in practice at least 20 years. And then when an ethical issue in the office came up with somebody, they would have a meeting of the committee, and we'd all, gnash teeth for 3 hours and vote on what should be done. So if your office doesn't have one, start one. It's really great for the lawyer who has something come up. It's a great go-to place for a lawyer to talk to other people. And again, it's mitigating if a bar complaint should result if they did consult with their office ethics committee. All right, who's this guy? Ted Bundy. Ted Bundy, yes, come on, you baby boomers that are in here. Ted Bundy, okay, who's Ted Bundy? Stereotype. Yes. Lawyer? Not a lawyer. Lawyer. Tricky because he's not a lawyer. There's nothing now. He's dead now, but he's been executed. But he went to law school. This is tricky because he did actually go to law school. In fact, he committed a lot of his murders while he was in law school, which we all kind of understand, right? He never graduated, but but he represented himself in many of them. Not very well, obviously. Interesting documentaries about him, though, for those who are not familiar. Very interesting. All right, here's a big one. Candor towards the tribunal. When was the last time anybody read this rule? Right? A lawyer shall not knowingly make a false statement of fact or law to a tribunal or fail to correct a false statement of material fact or law. So you can't lie to the court. You cannot, if you lie to the court, or you thought you weren't lying to the court, and you realize you lied to the court, and you're murdering the applicant. Right? Can we hold down a little bit, please? It's too warm in here. I just want to get through this so we can get out of here. Okay. Everybody knows. Make sure you cite the correct legal authority in your jurisdiction. If the jurisdiction does not have favorable authority, you still have to cite it to the court, and hopefully you can distinguish your case from the negative authority. Never offer evidence that you know to be false. This can be really, really thorny, and I'm not sure there's really a black or white answer to this. This goes to, my client's gonna testify and lie. What do I do? The loophole, and I hate that word, I think, is offer evidence the lawyer knows to be false. You weren't there, you don't know the client's lying or not, let's say, right? What do you do? It's thorny because it may require that you withdraw because you don't want to present false evidence. You may have to file an ex parte motion with the court that says, I have to withdraw, but I can't tell you why, because you're trying to also protect your client's confidentiality. The judge will know if you're filing this type of motion exactly what you mean. You don't have to go into any detail. You can file an ex parte under this rule. A lawyer shall inform the tribunal of all material facts known to the lawyer, which will enable the tribunal to make an informed decision whether or not the facts are adverse. So this is a good one for an ethics committee. This did come up when I was at the legal defender's office. What do you do? Now, the APDA comment is really interesting. Talk about law. In the first sentence, it says, it only applies if the lawyer knows that the evidence is false. So you can always say, well, I wasn't there at the time of the murder. I don't know that it's false, right? And then it says, it goes on to say, reasonable belief that the evidence is false does not preclude its presentation. So if you don't know it's false, you can present it. But then it goes on to say, although a lawyer should resolve doubts about the veracity of testimony or other evidence in favor of the client, the lawyer cannot ignore an obvious falsehood. Well, what's an obvious falsehood?
I was going to answer that question. I had another question.
Go ahead.
So,
I like your shirt. Your shirt says objection. Go ahead, real loud, please.
okay. So you're meet with your defendant and they just insist on wanting to tell their side of the story, their version of the events. And then later they testify something inconsistent with what they previously represented to you. What's the move there?
Great question. I was getting to that. Great question. So if you didn't hear, your client tells you one story, you put them on the witness stand, they tell a different story. What do you do? How many people have had that happen? Right? If you practice, right? If you practice any length of time, it's going to happen. So let me guess. Here's what you do, right? So you're getting ready for trial with the client. The client says, I'm gonna lie. Or maybe the client says, I'm gonna tell this story. Okay. You say, you can't lie, just tell the truth. Right? You're under oath, just tell the truth. The client says, I know more than you do, and I'll get convicted if I tell the truth, so I'm just gonna say this instead of this. You say, if you lie, I have to withdraw. And the client says, well, okay, I won't lie. And then they get up and they lie. So, what do you do? What do you do? I had this exact situation in a really difficult case. It was a double homicide. It was a coyote kidnapping case where my client and his colleagues had brought people over the border for money and then held them captive for more money. And the ones that they didn't get more money for, they killed and dumped them along I-17. This happened several years ago. My client was a Spanish speaker. The victim's families were Spanish speakers. Some of the witnesses were Spanish speakers. Every time I talked to my client, he gave me a different story. Every time I talked to him, he gave me a different story. And he insisted on testifying. I honestly didn't know what the hell he was going to say. And I didn't know what the truth was. He told me so many stories. Interesting about this case is he had gone back to Mexico after the murder. All of his colleagues and co-defendants, 5 or 6 of them, all of them had already served their prison time. So all of the witnesses, they were already done. They were already either on parole or had finished their sentence and came to testify against him. So they had nothing to lose. That's how old this case was. This case was prosecuted 10 years because he had gone to Mexico. So I didn't know what the truth was, but all the other witnesses were really consistent. So what did I do? I let him get up there. He talked and talked and talked through the interpreter. He looked the jury in the eye. I said, look the jury in the eye, and you tell the truth. All right? Just listen to the questions, tell the truth. We practice the questions. He got out there and told a completely different story, something about being in California, something that he had never mentioned to me. And you're like, Now, I was very lucky. My judge was Susanna Pineda, who, but very nice. And I had known her years ago when she was in the AG's office. And you remember Cleve Lynch from the prosecutor's office? He's retired now, but he was the most easygoing guy, and this was his last trial. And so it was kind of fun. It was a dead bang loser for me, and it was kind of fun. But I stood there going, God damn, what should I do? So what I did was I didn't comment on his testimony. I just asked the questions he and I had prepared, he was cross-examined, he said whatever he said about being in California. And on closing argument, I did not argue what he said, I just said, you heard from my client. You heard from my client, he didn't have to get up there in front of you and testify, and it's his constitutional right not to testify, but he wanted you to know what happened. And that's what I did. And I felt okay about that. But it's thorny.
Because when I meet with a client initially, I don't really need to know their version of what happened. Because I just need him to understand the charges against him, the elements of the state needs to prove, and see if the state can prove it, and then they'll have a decision to get a plea offer, and that's up to them if they want to accept it. But if they tell me something, and then they get up, yeah, you're right, it's thorny.
Yeah, if you're in a beautiful world, that's what happens. But they always want to tell you what happened. And then they always get some other bullshit story and they get understand. So, you know, if you can talk them out of testifying, because usually no good comes of that. I've had, I will say, every time I had a client testify, they said something on the stand that I didn't know about. Whether it was a lie or not, or they had just not bothered to tell me, I don't know. Either they were covering for someone else, they thought they were covering for a loved one, or they decided in the spur of the moment to make up a story. I never had a client that I didn't suspect was lying on the witness stand. I didn't know way of proving. Like I said, sometimes they would just, oh, I didn't tell you that. Oh, I forgot to tell you. I hid the showcase. So, yeah. So, the impartiality and the decorum of the tribunal, you know, we went over this. Just, you know, appreciate the decorum of the courtroom. Don't try and influence the judge. I don't know what that would look like. Nobody ever tried to influence me. And, you know, obviously no ex parte communications without the state's input. Don't communicate with the juror if they don't want to communicate with you. And the catch-alls, which is the engaging conduct, likely to disrupt a tribunal, whatever that means, right? No foot stomping. 8.2, don't make a statement that you know to be false or with reckless disregard for its truth or falsity. This is interesting. If you live in a county where judges are elected and you're thinking about running for office sometime, even though you're still a lawyer, if you're running for judicial election, you have to follow the code of judicial conduct. I thought that was interesting. I did not know that. Of course, that applies to the smaller counties. So be mindful of that if you think about running for a judge in a small county. This is the big one. This is the one the bar likes to charge people with, because I call it the catch-all, the fishing net provision. You know, professional misconduct to engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. You cannot get someone else to do something that would be unethical for you. You cannot get your paralegal to do something that would be unethical for you to do. That does not skirt the rule. And the big one the bar likes to charge is that 8.4D, engage in conduct that is prejudicial to the administration of justice. Very, very broad. Finally, a notice. The rule itself says you can't notice a judge for an improper purpose. Well, what's an improper purpose? I mean, you're not going to put in the motion anything improper, right? And of course, we have the one freebie notice. But if you're noticing a judge for cause, it can't be for an improper purpose. And by the way, the APDA does not have this rule in the model rules. This is an Arizona rule, which I found interesting. So if you're really into this, need some advice and ideas, the APDA actually has a podcast for each of these rules. So if you want more information about any of these rules, there's the QR code here. Links. You know, high standards of professionalism. We should set the bar. Okay, we shouldn't be the lowest one on the totem pole. We should be the highest. And again, without sounding too preachy, you know, we have a sacred duty under the Constitution to represent people and to you know, take care of people who, for many of whom, they go to last resort. So, you know, please take that seriously. It helps our reputation, everybody's reputation. It follows the rules and are extremely ethical. It is. Lawyer, not a lawyer. You're right. She was not a lawyer, but sometimes people think she is because not only was she an amazing pilot, maybe not so much on that last flight. She was a big woman's rights. She was a big woman's rights advocate as well. Okay, so let me wrap up. We have 50 more minutes. Let me, I know it's a warm and thank you all for bearing with me in this terribly warm room. Know your judicial officer. Very important. Who are they? Where did they come from? Were they a public defender? Were they a prosecutor? Were they a civil litigator for a big firm who's never been inside a courtroom and who's never had a trial? You can take the opportunity to train them. You shouldn't have to, but do it. Do it. I trained lots of Rule 11 judges. If you don't know the judge, talk to your colleagues, send out an email to everybody, hey, does anybody have any experience with this judge? Or just do a quick Google search, it is worth your time. Don't assume that a new judicial officer is stupid, all right? I had mostly prosecutors, because I knew most of the defense bar. Mostly prosecutors assumed because I was new on the bench, I was stupid. And I resented that. And, you know, a lot of us practiced for many, many years before we become a judge. And, you know, it's really bad to condescend to the judge. So, but you can train the judge without condescending, being condescending to them. Nobody likes being condescended to. But some of them do need a little training. The training is very limited for new judicial officers. I'll talk more about that tomorrow's presentation. It's shockingly crappy, the amount of training that a new judge gets. I was very lucky. I got appointed to the criminal bench. Thank God. Because if I had been appointed to probate, or God forbid civil, you know, and they just throw you in there. They just throw you in there. Nobody, you know, nobody told me that. So it's good to know who they are. Because if they're a former public defender, they're going to know what you're talking about. And be prepared to school them. If they are new, they don't really know anything. And of course, you can school them to your client's advantage. It's the bottom line.
With decorum. With decorum.
Absolutely, always with decorum, yes. Do they pay attention? Do they read your motions? Are they prepared when they come into court? All these things that a judge should be doing that they may or may not be doing. Review files in advance. Do they take notes? Now, sometimes judges will take notes. They're sitting up at the bench typing and taking notes. I didn't do that because I always thought it looked like I was playing on my computer. So, and I'm old school, so I took written notes. Do they give a shit? Like, do they give a shit about your client? Some do, some don't. But just know your audience and tailor your presentation to that audience. Bias. Right, we all have implicit bias. If you can gather what that judge's bias might be, you know, is it more than just, oh, this judge doesn't like me, so they're not gonna like my client. Think about strategies you can use to sort of mitigate that effect. We could spend a whole hour talking about just that. All right, trick question. Everybody knows who this is, right? It is Kim Kardashian, lawyer, not a lawyer. She finally became a lawyer after how many years of telling us she was a lawyer? She is now actually a lawyer, as of just like 2 months ago. She apprenticed under California law, which is the way to become a member of the bar under California law. And so she is actually now a lawyer, although I understand she took the baby bar 4 times, that's what Wikipedia said. Okay, she is actually a lawyer now, so look out, guys. All right. And one more. Who's this guy? John, please. Yes. Yes. John, he's lawyer, not a lawyer.
Lawyers like to look out that way.
He's a lawyer. He's a lawyer. He, of course, is a brilliant comedian, writer, producer, actor for the baby boomers. He probably fell in court. He went to Cambridge Law School. So I'm leaving you with this hilarious photo. This is the Supreme Court of Canada. This is their official robing. It looks like Santa Claus. But I wanted to leave you with a smile. I thought this was just